Hey, good day. Welcome to episode 7 of our law lecture channel. In today's episode, we will be discussing a case which you will encounter in Criminal Law 1, the case of US versus Chong. This is an old case, in fact, a 1910 case, which discusses the application of mistake of fact. You will encounter mistake of fact at the early stage of Crim 1. So let us now discuss the case. So here, the accused Chong was employed as a cook. With him, actually, is the victim, the deceased, Gualberto, who worked as a houseboy or muchacho, and they both worked at the officers' quarters number 27 at Fort McKinley in Rizal province. So they stayed and slept in the same small room, and the door of their room has no permanent lock. It only had a small hook, diba? The one that we see or encounter in old houses, small hook. So they were placing chair behind the door to reinforce it, and their room has a small window, but there's no other opening. One night, on August 14, 1908, at about 10 o'clock in the evening, the accused was then sleeping, was already sleeping, was suddenly awakened by someone trying to force open the door of the room. So he sat up in bed and called out twice, "Who is there?" Sabi niya. So tanong siya, "Sino yan?" Sabi niya. But the man outside did not answer. And take note, it was dark then because there was a small room, only a window, no other opening. It is 10 o'clock in the evening. So the accused, feeling that the intruder was a robber or a thief, leaped to his feet and called out. So nagbanta siya. "If you enter the room, I will kill you." Those are the words uttered by the accused. So he warned, no? He warned the person outside. Instead of stopping or instead of introducing himself, the person struck just above the knee, or the accused was struck just above the knee by the edge of the chair which had been placed against the door. So the person outside continued to force open the door, which caused the chair, no, to hit the accused. So the accused was confused. He got his kitchen knife, which he kept under his pillow, and thereafter wildly struck the person he believed to be a burglar. It turned out that person was his roommate, Pascual Gualberto. So Gualberto died the next day because of the stab wounds, no, inflicted against him. Question now: is the accused liable, criminally liable for the death of Gualberto? But before answering that, let us first answer or explore why the accused had a kitchen knife. Di ba? Kung matutulog ka, bakit may kutsilyo ka sa ilalim ng unan mo? Well, based on the case, it was stated there that there had been several robberies in Fort McKinley not long prior to the date of the incident, and one of which took place in a house in which the accused was employed as a cook. And as the accused alleged, it was because of these repeated robberies that he kept a knife under his pillow for his personal protection. So, yun yung rason. So again, The issue is whether or not the accused Chong was criminally liable in killing Gualberto. So in this case, before answering that, the court discussed the doctrine of mistake of fact. Okay, so the Supreme Court said, in broader terms, ignorance or mistake of fact, if such ignorance or mistake of fact is sufficient to negative a particular intent, which under the law is a necessary ingredient of the offense charge, then it cancels the presumption of intent, and it works likewise as an acquittal. Since evil intent is in general an inseparable element in every crime, any such mistake of fact shows the act committed to have proceeded from no sort of evil in the mind necessarily relieves the actor from criminal liability, provided always that there is no fault or negligence on his part. Okay, so the court applied that principle to the case. According to the court, a careful examination of the facts in this case convinced us that the accused, Chong, struck the fatal blow alleged in the information in the firm belief that the intruder who forced open the door of his sleeping room was a thief, from whom or from whose assault he was in imminent peril, both of his life and of his property, and of the property committed to his charge. That in view of all the circumstances, the court said, as they may have presented themselves, the accused acted in good faith, without malice or criminal intent, in the belief that he was doing no more than exercising his legitimate right of self-defense. The court emphasized that had the facts been as he believed them to be, he would have been wholly exempt from criminal liability on account of his act, and that he cannot be said to have been guilty of negligence or recklessness or even carelessness in falling into his mistake as to the facts or in the means adopted by him to defend himself from the imminent danger which he believed threatened his person and his property and the property under his charge. Take note here, Chong was not negligent. Why? Because he repeatedly asked the person, the identity of the person who was opening the door. In fact, after asking that person about his identity, he even warned the person, diba? That if you enter, that something will happen to you. Despite that warning, that person, the deceased, continued, which forced Chong to actually defend himself. So in this case, Chong was acquitted because here the mistake of fact negated Dolo, negated the criminal intent, which made him not criminally liable. So as a way of review, mistake of fact may negate Dolo when the following elements are present. So whenever given a situation where there appears to be a mistake of fact, for it to negate Dolo, these three must be present. Number one, the acts done would have been lawful had the facts been as the accused believed them to be. Number two, the mistake of fact is not due to negligence. And number three, the mistake is not accompanied with criminal intent of the offender. And if you notice, all of these elements were present in the case of Chong. And because they were present, then the court acquitted Chong. Right? Thank you. That's all for this episode. I hope we learn the basics on how mistake of fact negates Dolo and make the perpetrator not criminally liable. Thank you.